Need to sell real estate in a conservatorship estate? Hi, I'm Darren Findling of the Probate Pro, and we're going to examine SCAO Form PC 646. That's SCAO for State Court Administrative Order, PC for Probate Court. This form is readily obtained through a Google search, or you're welcome to call my office. We'll give it to you free of charge. I'm going to explain when you use this form and when not to use this form. Let's start with when not to use the form. There is another form called Petition for Sale of Real Estate. That form is used when you're administering a deceased probate estate. When you're administering a probate estate and you need or want to sell real estate, that is the form that you use. This form is not used in deceased estates, and it says it right at the top of the form. With all of these state court administrative order forms, there are statutes and court rules that guide its use. And it's important to examine the statute and court rule, read them, so that you understand how the document is used and any of the rules that relate to it. And we strongly urge you that when using these forms to work with a skilled, competent probate practitioner who understands how to navigate through the probate process. So let's work our way through the document. In the top left corner, you'd identify the county in which the the conservatorship estate is pending. In the top right corner, the case number. As you can see at the top, that little note that just reminds you that this form, although it sounds very similar to the form used in deceased estates, this is not when you use the form. You'd identify the name of the estate and then your relationship to the estate. So for example, are you the conservator or are you the guardian? There are certain times when a guardian may be involved in the disposition of real estate. It's rare. So generally it's the conservator that's using this form for purposes of having the legal authority to dispose of, sell, lien, or do something with the real estate, which is prohibited both by statute and the letters of authority. There's a specific restriction in your ability to do so. So you have to get a court order before you can affect real estate. As you continue to move through the document, you'll see that number 2 says, what is your intention? Why are you asking the court to be involved in this transaction? So the options are sell, dispose of, it's a kind of a vague term, mortgage, pledge, or ask for a lien to be placed on the real estate. So again, without a court order, you don't have the right to do any of those actions. In addition, it asks for you to identify the legal description of the real estate. So remember, in Michigan, you're not only identifying property by a commonly known address like 1234 Main Street, but there's a legal description which identifies the lot number, the subdivision, the LIBOR page, maybe it's a meets and bounds description. And if it is a manufactured or mobile home, you'd identify the vehicle identification number, because with those types of assets, they are registered through the Secretary of State rather than the Register of Deeds. So you need to go back to an old deed or old mortgage to identify the legal description of the real estate upon which you're asking the court to be involved. Then the next section says for the purpose of. Why are you doing this? Well, maybe it is to liquidate the asset to raise money so that you can take care of the ongoing expenses of the conservatorship. Maybe it's because there is a foreclosure occurring and you need to sell to stop the property from foreclosure. So you have an opportunity here to include a narrative. And within that narrative, you can attach additional information, additional pages, and additional supportive information. Then it identifies to whom you are doing this transaction with. So for example, if you are conveying to a third party, you'd indicate the name of that person. Maybe you're getting a mortgage and you'd identify the name of the mortgage company or bank, and then the amount of money, and then under the terms. And here there's not a lot of room here to identify all the terms. So we tend to ask, and usually the courts want additional information. So for example, if it's a real estate transaction and there's a purchase agreement, then attach the purchase agreement. If it's a mortgage, attach the proposed mortgage, and attach all the relevant information to give the court a full understanding of the transaction that you're asking the court to approve. Because as you can imagine, the sale price and the person purchasing it just tells part of the story. There are also additional terms and conditions that are relevant for the court to analyze the situation, to analyze whether there's an appropriate bond that would need to be required, whether the transaction is in the best interest of the individual. So maybe, for example, if you're selling the real estate, you may have done an appraisal, you may have done comparables. You'd want to attach that information to give the court a full picture and understanding of the transaction upon which you're asking the court to approve. From there, it wants additional information. So this is the color, as we would say, to the transaction. The court wants to know the state equalized value of the property. So for example, the state equalized value can readily be obtained from the most recent tax statement, tax bill. You can see it says SEV for state equalized value. You'd take the information off of there. 2 times the SEV is the approximate value. And then it asks for a copy of that recent assessor's statement or tax statement, and again, you can attach an appraisal there also. In addition, it wants to know if there are outstanding liens. So that means, is there an outstanding mortgage? Is there a home equity line of credit? Are there current assessments or taxes that are owed? Is there an IRS lien? Those are the types of liens that the court would want to be aware of to understand the financial picture relating to the real estate. As you move down to number 5, it wants to know additional assets. So imagine if the court is deciding whether it's appropriate to sell this real estate, if there's $1 million sitting in another bank account, that's relevant. If there's no money, that's also relevant. So the court is trying to understand a holistic picture of the financial transaction in a particular space related to the real estate, as well as a holistic understanding of the other assets and liabilities of the individual to understand the full picture of what's being asked. It wants to know the unpaid taxes and whether the fiduciary, meaning the conservator, is currently bonded. Remember, a bond is a guarantee of performance. It is a process which I've explained in another video called a bond of fiduciary, where the court wants to be assured that if you breach your duties or steal the money, for example, that there is a recoverable bonding company which would guarantee your performance as conservator. And often in these real estate transactions, when you're asking the court to be involved in a transaction involving the sale or liquidation of real estate, the court is going to impose a surety bond to ensure that you perform your role correctly, and that if you fail to, there is a recoverable source in the form of a bonding company. Now again, with bonds, this can be a real hurdle for a conservator because many people can't qualify for a bond for a variety of reasons. So all of a sudden, the conservator's personal assets and their risk and their credit is in scrutiny for purposes of qualifying for that surety bond. So when you're ready to sell, if you learn that you need a surety bond, please understand that your credit and your financial risk are going to be examined on a bond application to determine whether it's suitable to provide you with a surety bond in the transaction. And again, I've explained that in other videos that you can look at to understand how that process works. As you continue to move down the document, it asks for monthly income and expenses to understand, again, a full picture of the financial transaction that's being entered into. On the back side of the form, you are again identifying whether any interested persons as defined under the statute and court rule have changed from the initial petition for conservatorship. So you want to constantly update the court as to the interested parties and their addresses. And this is typical of most of the state court administrative order forms. You're constantly updating the court to provide them with current information about the addresses of the interested persons. And that's really for purposes of ensuring that service through a proof of service that is done when these are filed and you send it out with a notice of hearing, that you're complying with the court rule for purposes of serving the correct people at the correct address. Number 8 is really the essence of this. You're asking the court to do something in a petition. And here's the request. You're asking the court to approve a sale, the disposal of, the mortgage, a pledge, a placement of a lien on the property described on page 1 of that document. So again, a complicated document to fill out. At the bottom, the typical penalty of perjury clause with all of the state court administrative order forms. You're signing under the penalty of perjury. You're certifying that it's true to the best of your information, knowledge, and belief. So please fill that document out very carefully. understanding what the court rule and the statutes require of you in your fiduciary role. An opportunity for the petitioner to sign on the right side, and if there's an attorney, to sign on the left side. Again, a little bit of an involved document. Often real estate transactions can be both confusing for people and technically challenging. Again, we strongly urge you to work with a probate practitioner who understands this area of law. At the Probate Pro, we are passionate about everything probate. If you have questions regarding the petition, regarding real estate in a conservator context, or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.